Greetings and welcome to Lobes and Robes, How Neuroscience Can Change the World. This podcast is sponsored by the American University Center for Neuroscience and Behavior and explores the links between neuroscience and key policy questions today. I'm Susan Carl, a professor of law at American University Washington College of Law, and I will help lead discussions throughout our series. My co-host is Dr. Colin Saldana, a professor of neuroscience at American University. He is also the director of the American University Center for Neuroscience and Behavior and the president-elect of the Society for Behavioral Neuroendocrinology. This podcast is for anyone interested in how scientific discovery can make the world a better place. Thanks for listening. Welcome back to Lobes and Robes. This time, we are going to be speaking to one of my colleagues, Gustavo Ribeiro, who is an associate professor of law at American University Washington College of Law. He teaches and writes in the areas of evidence, civil procedure, criminal procedure, and jurisprudence. And his scholarship focuses on the philosophical and psychological dimensions of legal proof. His previous work has addressed topics such as misinformation, discovery, standards of proof, and expert evidence. He holds his degrees, and he holds an LLB degree, summa cum laude, from FGV in Rio de Janeiro, and also an SJD from Harvard Law School. And he's also the husband of Allie and father of 2 kids. And I'm especially excited to introduce Gustavo because he is going to become the new co-host of Lobes and Robes for season 5. And he's a wonderful teacher. He's very loved by his students, and he has a real knack for taking complex legal issues and making them comprehensible and simple to follow. So I think he's going to be a wonderful co-host. But we thought we'd start by interviewing him and his work and his knowledge around questions of the use of scientific evidence in courtrooms, since that's a very important part of the field of neurolaw. So welcome, Gustavo.
Hi, Susan. Hi, Colin. Thank you so much for this invitation. I'm thrilled to be here talking to you. I'm a big fan of the work you two do with Lobes and Robes, and I'm happy to be a part of it.
Wonderful. I'll start with the first question. One of your areas of interest as an evidence professor and scholar is the use of scientific evidence by courts. Can you tell us a bit about what you see as the special challenges and issues in that area?
Absolutely. That's a great question. There are actually several different ways to answer that question because the challenges are many. So on the more dogmatic side, there's the issue that courts across the country face every day. That is of determining, what scientific evidence, and I'm using air quotes here, is sufficiently reliable so that it should be admitted at trials or other court proceedings. That is what scientific evidence juries get to hear. Now, you can group that set of challenges as to a related one is, once admitted, how do you properly weigh the probative value of that scientific evidence? This is particularly challenging given the role of juries and judges as non-scientists. So, what to admit, what's sufficiently reliable to admit, and once admitted, how much weight you give to that expert evidence, scientific evidence. That's one group of challenges. Now, a broader answer actually involves the challenges of mediating between law and science as 2 different epistemic cultures, right? So the legal system, and here we're talking about courts in particular, they, for instance, are committed to finality, right? So we need to make decisions, right? So trials need to end, ideally with a verdict, within a reasonable amount of time. Science, by contrast, is inherently provisional. It ideally always open to revision, debate, further inquiry, often with a much longer time horizon. So this means that science is much more tolerant of uncertainty. The legal system, not so much. So there are other challenges that are conflicts between law and science as do cultures, but I think we can start there.
That makes a ton of sense. Yeah. And when you're teaching your students about these issues, how do you explain this, or to a lay person, how to think about this disjunct between the cultures and discourse communities of science and law?
Absolutely. So for my students, of course, as your listeners know, at law schools in the US, the main pedagogical tool are cases, law cases. So cases are really helpful to illustrate how challenging it is for non-experts judges to decide which scientific evidence they deem sufficiently reliable to show jurors or to decide for themselves. Even how to think about how to start answering that question of what's sufficiently reliable is challenging. So, for instance, one case that is probably a staple case in every evidence class in the country is the 1993 U.S. Supreme Court case, Daubert v. Merrell Dow Pharmaceuticals. That was when the court set forth a not exclusive, but a checklist that trial courts could use in assessing the reliability of scientific testimony. Like in that court, actually, the court did two things. First, to set up the functions of what trial courts should be doing. They should serve this gatekeeping function of determining what's sufficiently reliable. And if the answer is not reliable, then it's not admitted in trials and proceedings. And if it is reliable, then it could be admitted. And then the court went on to say, here's certain things that courts might be thinking about in determining what's reliable. And we can get into those, right? So that's one thing for students, cases. That's the main pedagogical tool. I also teach a seminar, which will discuss more in-depth legal proof issues, including scientific evidence. And there we have more time to read scholarship and other reading formats from other disciplines, psychology, philosophy, neuroscience, you name it. It's a fun class to teach and a fun thing to pick which assignments to give to students. Now, you also ask what students and members of the public should know and how to teach them. And that's a good question. So I think I'll go back to my previous question, how law and science bring different epistemic. And because of that, I think the translation between both of them should be done carefully. I think that's one of the main teachings that students and I think the public should know, that when translating between science and law, that there's some work to be done there. So I already spoke of two differences, right? So the difference between different approaches to finality and uncertainty. So I'll give you two more here. So one is there are different approaches to change, right? So law is, for the most part, more resistant to change. So think about the role of precedents, right? We value precedents. We think, or at least we used to think, that decisions should be followed. Prior decisions have some authority that should be followed. Now, science is, in general, again, and with notable exceptions, seems more open to change. That's another dimension. So another difference is the role, and this is an important one, is the role of general statements and individualized statements. So science is much more concerned with statements about groups, about generalizations, averages. And law, and here we're talking about courts again, it's much more concerned with individualized statements. Courts need to assign guilt, liability, causation as to a specific individual, right? And that causes a big problem into if science is telling us statements about averages, about groups, how we translate that statement about a group to a statement about the individual, be it the defendant or the plaintiff. That is a big problem that we should be concerned with and thinking about.
Yeah. Do you think courts are getting it right? Are they able to do that translation? Are they admitting the right scientific evidence and excluding the right? I know Daubert says something about the authority, judging the authority. Is the proposition accepted by a reputable scientific community? How do courts figure that out? And do they figure it out right?
That's a good question. So again, in that 1993 Supreme Court case, the Daubert case, Supreme Court sets up a list of things that trial courts should be thinking about it in determining what scientific and other technical evidence it's reliable enough to be admitted. So like, for instance, the court listed, testability, right? So whether a scientific theory or method can be or has been tested, right? So those listeners who read Karl Popper, the famous 20th century philosophy of science, that was one of his big ideas. And the court listed that as one of the things that lower courts should be thinking about in determining whether some scientific theory or methodology is sufficiently reliable. So if it can be tested, if it has been tested, versus whether it's a simply subjective, conclusory approach that can't be reasonably assessed for reliability. So that's one thing that courts should be, or at least can be thinking about, right? So courts then lists other interesting criteria. So peer review and publication, whether a particular theory or methodology has been subject to peer review and publication. However controversial that criteria might be, that's one thing the courts point at. We all know the problems with peer review publications, but courts seem to think that's an important metric. Also, the potential error rates for a particular discipline, theory, or methodology, right? If it's a known error rate, what is it? What is it in theory, and what is it, when applied to this particular type of situation? That's an important one that we can come back to. Are there standards and controls in performing this methodology? How are they maintained and who maintained them? And last but not least, whether that particular theory or methodology has generally been accepted in a relevant scientific community. So again, the court meant those to be a non-exhaustive list of just examples the court may consider in deciding what scientific expert is sufficiently reliable to be used in courts. And there are other criteria one can imagine. We can talk about, citations. We can talk about affiliations. We can talk about grants. We can talk about awards. It's hard to imagine if one can ever come up with a single list that will sufficiently distinguish between, reliable and unreliable scientific statements, testimony, methodologies in every case. I feel like what's reliable may really differ depending on the discipline, the methodology, the application, the case in hand. I think another interesting question is, and interrupt me if I'm going on too long, is whether the court is even the right entity to be making the determination about what's reliable or not at all, right? Or maybe should courts defer to scientists, to the relevant scientific community about what's reliable in their own disciplines? And if so, how strong should that deference be?
Yeah, Colin, I'm wondering, when Gustavo describes so well the Daubert case, which is the key case on the admission of scientific evidence in courts, do you think the court got it right? Are those the right criteria for what's good science versus what might be or fringe?
I'm so happy that you asked that, Susan, because as I was listening to Gustavo, in my head, I was conflicted, because when I think about good science, I think about the quality of the experiment, the strength of the data, the interpretation of these data. Is it clean? Is it equivocal? Gustavo, on the other hand, seems to be using reliability as a very important measure. And I am wondering, Gustavo, does the question of validity ever enter the legal scenario? Of course, things can be reliable, as in you can do an experiment again and get the same result. But when it comes to asking the question, what actually are you measuring in order to come up with this interpretation, does that ever come up in the courts?
Absolutely. It does come up to the court. And I think this is an interesting one. I feel like courts sometimes merge those two concepts. I think they sometimes refer to reliability not only as, consistency, but also as accuracy, which I think some scientists might describe more as the validity. So I think courts use the term reliability to mean both accuracy. Can we trust the results of this measurement or of this methodology, of this theory? And also, is this sufficiently consistent that its application in this particular case is sufficiently trustworthy that we can take them at their word and then decide the case accordingly?
One of the things as a follow-up, Gustavo, it's not a conflict, but the lack of overlap. You mentioned this earlier about certainty versus individual arguments. As a scientist, I don't worry about being wrong in my interpretations, but there is always that element of I may not be totally correct. And I can see that being very problematic for courts. Has that ever come up in a discussion?
Absolutely. I mean, courts are also concerned about being wrong, or at least they should be. Of course, at the end of the day, they do have to make a decision. And there are rules, there are procedures in place to try to protect against potentially mistakes depending on what the court thinks or the legal system thinks it's at stake. So here's an example, right? So in criminal cases, the presumption is defendant's liberty is at stake. So we are very concerned about being wrong. And not only we're concerned about being wrong, we are more concerned about being wrong in one particular way than the other. We're more concerned about putting an innocent person in prison than we are concerned about letting go a guilty person, right? That's a policy judgment that society has made, that courts have accepted for centuries now. So in criminal cases, you're not only concerned about being wrong, but we're concerned about being wrong in one particular way. The assumption in civil cases is quite different. We're concerned about being wrong. We want to get things right. But we're less concerned about being wrong one way or the other. And the assumption is, well, it's all about money. No one's liberty is at stake. The parties are rational free agents. They can decide what's best for them. So one way the law mediates that different approaches to mistakes and the potential social costs associated with each type of mistakes is to modulating the standard of proof, the burden of persuasion, in other words, that a party needs to meet. So, for instance, go back to criminal cases, right? So the idea that the prosecution is to prove its case beyond a reasonable doubt, right? So we need to be really sure how sure? Well, beyond a reasonable doubt that this defendant is indeed guilty of the crimes he was charged with. Only so we will convict. We can be pretty sure, but that's not enough in a criminal case because, goes back, we are concerned about one type of mistake. The being concerned about mistakes is definitely a thing that courts are, only there are concerns about different types of mistakes depending on the case at hand.
Understood. Thank you.
Does that make sense, Colin? Does that, from a scientist's perspective?
It does. It is two different kinds of certainty. What Gustavo is talking about is making a wrong decision and, jailing somebody who's innocent. And when I think of certainty, I'm actually thinking about the quality of the data. So if I look at a data set and the confidence that I have in interpreting that data set is something that I worry about, which brings up an associated question, Gustavo. So what are the dangers of pitfalls to watch out for when using scientific evidence in court?
Several. So one big one, I think it's something that has been studied and measured before, is just an over-evaluation of scientific evidence, right? So this is particularly problematic in the criminal justice system when we have many defendants who just don't have the resources to pay for an expert to contradict or the one from the state, from the prosecution. So the concern here is that juries may become just overly impressed with the scientific jargon, the demeanor, the credentials, the claims that the conclusions and methodologies in a particular discipline or methodology are much better than what they actually are, or at least what the data suggests they are. So this is a concern that, juries might overvalue the scientific evidence more than what the data supports. And of course, the parties using that to their advantage. So that's one pitfall. Another pitfall is when juries find themselves caught between the so-called battle of experts, right? So now you have parties with, this is quite common in civil cases, non-criminal cases, where parties have resources to hire their own experts. Now you have two experts, one of each side, with matching credentials, matching perceived credibility, saying contradictory things, saying A and not A. And who should the lay juror believes when, the other evidence underdetermines which expert is right? And how do we make sure that decision is justified, is reliable, and they're not just going on which expert is, better soft-spoken or, looks better at trial. So those are at least two big pitfalls that the law has been concerned with for a while now.
Fascinating. Thank you. Susan, that makes me think about presenting evidence. I'm wondering about how does scientific evidence can be packaged or presented? Does that change the likelihood that courts will accept it into evidence?
So I think the word here is educate, right? I think this is the model that courts, the legal system, at least in the federal, in the U.S., have adopted. So attorneys and experts are supposed to educate courts and jurors so they can understand and hopefully properly apply scientific evidence to the case at hand. Education of juries is, in most part, what trials are for, right? So we educate jurors about the law, about the facts, and when needed, about scientific evidence that is relevant to deciding those facts. This can be done in many different forms, right? So attorneys educate jurors about the law, the facts, and the evidence in their opening, closing statements, when they are asking questions to witnesses in cross-examination. But what can also think about other types of proceedings. So, for instance, courts have often adopted what they call like a science day, right? Well, the parties call experts for a full day or maybe a half day of presentations and debate to educate the judge about a particular scientific issue or a particular scientific methodology, such that the judge can then make a more informed determination about whether this or that is sufficiently reliable. So there are many ways in which we can try to enhance the prospects that the scientific evidence would be used correctly and appropriately at trials. And courts are getting, I believe, more and more creative as to doing that, given that one finds itself increasingly using quite sophisticated scientific evidence in courts, be it at antitrust cases, be it a criminal courts with forensic evidence. So it's all about how we can be creative in educating judges and juries.
Wow. What about DNA evidence, which seems to be such a, important kind of scientific evidence being used in criminal cases, and I guess other cases too? Any thoughts about that?
Right. So DNA is an interesting one. So let's talk a little bit about forensics and forensic sciences. I think that gets to it. I think the legal system now, and it's been for a while, coming to a realization that a lot of the techniques that police, other law enforcement agencies, prosecutors have used in prosecuting individuals for crimes allegedly committed, and many of which courts have allowed to go in to be admitted, many of those techniques didn't really have good data to support them, to support their validity, their reliability, right? So one can think about the use of fingerprints, the firearm analysis, so ballistics, right? Or hair sample analysis, or bite marks analysis, or footwear analysis. And in 2016, I believe, there was a famous, I'm sure you know about it and your listeners might know about it, the so-called PCAST report. So the PCAST, that's the President's Council of Advisors on Science and Technology, right? So under the Obama administration, there was a big splash about trying to reckoning moments about reevaluate the validity and reliability of forensic science used in courts. And there was a lot of concern and a lot of alarms, often coming from forensic scientists themselves, that a lot of the techniques used were just not used properly, or the claims witnesses were making were not supported by the data. So there was a big movement pushed by the federal government and other agencies to study more carefully those analyses. And what came after years of extensive research, that report and others found disturbing problems across many commonly used forensic methods, which includes, a lack of rigor, appropriate studies establishing their reliability and their validity. It was found how experts would often claim that the error rate or the validity of those techniques were way, way, way more than what the data actually suggests. So, for instance, when talk about fingerprints, see transcripts of experts saying that it was infallible. It could not be wrong, right? Or, for bite marks, you actually have transcripts of courts allowing experts to testify that the chances of a bite mark analysis being wrong is like 1 in 6 trillion. Like this, like bizarre remarks that courts often allow. What that report and others at the time did was to show how little support there were for the data. That really helped. I think that caused a change. I feel like courts, a lot of those disciplines have did some work and improved the data available to support their claims. Others, not so much. And some courts now are more reluctant to allow either some of those evidence or for witnesses to make claims about error rates or about reliability that are just not supported. Right. Okay. So going back to DNA, which I didn't forget, I think DNA is the one that came out looking really good after all this, right? Of course, there's still concerns about sometimes the way it's used, not only in terms of, the testing, the collection of samples, storage of samples, but also the types of claims that DNA scientists can make in the courthouse. What exactly DNA matching means? What is exactly the nature of the claim? Can you sufficiently identify an individual based on the sample? What exactly are you saying? So going back to the translation between a scientific claim and a claim that courts expect. So there are still concerns about DNA evidence, not about its validity or reliability if done properly, but how to educate the court and juries about what the results of a DNA analysis mean. Are we really saying point to individual? Is it a probabilistic type of statement? What is it? I think that's the concern with DNA.
That makes a lot of sense. What about neuroscience? Are there special concerns about using neuroscience in courts?
Well, yes, that's a fascinating topic. There are definitely concerns, right? There are promises. There are things that, we hope we'll be able to get to, but there are potential concerns, right? So many of the general problems that we discuss about other types of scientific evidence also apply to neuroscience. But I do think neuroscience raised some special problems, right? So first is a so-called, the brain overclaim syndrome, right? So a tendency that jurors might just overvalue scientific evidence. And here is particular problematic with neuroscience, right? So there's research suggesting that people and jurors in particular are particularly susceptible to treating, brain-based explanations as more credible, even if the underlying logic might be flawed or the data might not support those claims. So courts must be concerned and try to defend against that. But that's one problem, right? There's also the translation problem. Like, how do you translate what the neuroscience can tell us with sufficient support to what the law needs to decide, the questions the law needs to decide, right? So can we talk about causation, or we just talk about correlation, right? Can we individualize the problem or the finding, or are we just talking about, averages within groups? And of course, neuroscience is a rapidly evolving field. Is the new technique in town? Does it have enough support and shows of reliability that should we use to potentially imprison an individual? Or should we give it time so it matures before we use in a court. So those are some of the issues that are specific to neuroscience.
It makes me think, Gustavo, of when scientific evidence is presented to juries, is it mostly in the form of clinical data, like imaging, or are there actual discussions about the basic science that is being conducted, particularly in the neurosciences?
I'll say it's mostly clinical. Again, court proceedings, trials, they're generally trying to make pretty specific factual determination, like about an individual conduct or mental state. And they're usually trying to involve some causal connection, right? So issues of causation, responsibility, competence, intent, guilt. And so they're trying to make statements, conclusions that are related to specific individuals. And courts are usually trying to look at or hope for parties to admit specific applications of basic science, right? So we can talk about clinic diagnosis, right? So be it for cancer or injuries, brain injuries is a big one using neuroscience in particularly civil cases, right? We could talk again about forensic science, right? So application, DNA, taxology, all of that, or medical imaging, right? MRIs, fMRIs, CT scans, or maybe psychological assessments, risk evaluations for probation or competency. It's mostly clinical. Now, basic science, I think, does play a role in educating, again, courts and jurors about how to understand those applied science claims, right? So expert witnesses here often may refer to basic principles such as, we all know that research on memory tell us X, Y, and Z, or, research on perception tell us, A, B, and C, to bolster and support the clinical claims they're trying to convince the court and juries that it's true. And I think that the same is true with neuroscience, right? So I'll say it's mostly clinical, but basic science is there to educate the decision makers in how to interpret those clinical claims.
Thank you.
We're unfortunately starting to run out of time. Before we end, I'm wondering what you see as the hot topics for the near and midterm future in the use of neuroscience evidence in courts.
Gosh, there's so many. Again, neuroscience has been for a while now, for decades now, being promising as this, new greatest thing that will solve all our problems in determining, issues of intent, issues of culpability, issues of lying, right, as a lie detector. And, we haven't seen all the fruits of that work yet. I mean, there have been increasingly courts are, I think, more accepting more certain types of claims based on findings from neuroscience. Can talk about courts' decisions about, the culpability of minors, right? Giving evidence about their developing brain at early ages. Talk about courts' acceptance of claims having to do with addiction, right? And behavior of addicts in terms of, again, of culpability and intent. There's many other topics that I think we still hope that neuroscience will deliver. There's at least two, I think, that are interesting, right? So, I'm not going to sound very creative here, but I think AI is an interesting one, right? Insofar as AI can help not only neuroscience develop as a science, but it poses new topics about issues of authentication, issues of reliability. I think that's one topic. Another topic, and here I'm going to take the liberty of making a shameless plug here, is my recent research on misinformation, right? So I think neuroscience can help, and there's been some work on this to try to understand why people fall prey to misinformation, why people are susceptible to misinformation, what kind of interventions can be done to fight misinformation. I think there's some interesting work on that front that is now maturing. And I think there are important lessons, and this is something I've been writing about, to the legal system, both in terms of, regulating spaces, social media, etc., but also better educating juries and better equipping juries with the tools to make informed decisions. So those are at least two hot topics that I see.
Yeah, absolutely. It sounds like there's a whole lot to talk about in season 5.
Absolutely.
Absolutely.
Well, thank you so much, Gustavo. It's great talking to you. I really look forward to handing over the co-hosting responsibilities to you. I think it's going to be a wonderful season.
Thank you so much, Susan. Thank you so much, Colin. As I said, I'm a big fan of the podcast. I'm very excited to be a part of this with Colin. I'm sure listeners will miss Susan, but hopefully you can come back for special appearances.
I hope so too, Susan. And I do want to end with saying a very, very big thank you to you for your efforts and the time that you have taken to promote these podcasts. It's a wonderful collaboration between the Center for Neuroscience and Behavior and the Washington College of Law, and I look forward to continuing this work with Gustavo in Season 5.
All right. Well, then we'll sign off for now.
Well, that's it for this podcast episode. Thanks very much for listening. And as always, we welcome your feedback at neuroscience.policy@american.edu. We hope you'll join us again for our next episode. And do let us know if there's anything in particular you'd like to hear more about.